Good afternoon, and welcome to this webinar exploring the impacts of new and upcoming legislation on Australian employers. I'm Ray Welling, Editor-in-Chief of Workplace Info and Workplace OHS, and today we're going to look at a variety of areas you need to be aware of when it comes to managing the people side of your business. Joining our panel of experts today is Jennifer Anderson, who's the manager of the anti-bullying case management team for the Fair Work Commission. And we also have Paul Monroe, who's the IR writer for Workplace Info. Jennifer, Paul, welcome.
Hello. Thank you, Ray.
That's all right. And to start off, as always, just to let you know that if you have any technical issues or you'd like to post a question to our panelists during the presentation, you can do that by typing your query into the chat box in the lower left corner of your screen. We received a few questions in the lead up to this webinar, and we'll get to as many of those questions as we can during the time we have together. I'd like to point out the information provided in the webinar today is general information only, and it doesn't take into account your own particular work situation or your objectives and needs. Before acting on any information contained in this discussion, you should consider the appropriateness of the information, having regard to your own objectives, work, and financial situation and needs. Now, Jennifer, let's start by looking at the anti-bullying activities of the Fair Work Commission. How does that work? Jennifer?
What the jurisdiction has been since the 1st of January. So, and we'll have a look at the sort of the general statistics in relation to the number of applications and some of the decisions or orders that have been made to date. So things Ray was saying early on, that look, I won't be providing advice or commenting on the anti-bullying policy itself. The information I'm providing is general, and obviously it's not possible for me to be definitive. These are still, even though they've been in operation since the beginning of this year, they are still very new provisions, and there are still few precedents to rely on. So again, there's no substitute for reading the Act itself and taking the appropriate legal or professional advice as Ray suggested. And the views are my own and not taken to be those of the Commission as a whole. So I'll just go over some of the key elements of the current jurisdiction and just to set some context for the things that I'll be discussing. It has a very broad scope of applicants. It's broader than the scope that the Commission would usually deal with. It's looking at workers under the definition in the Work Health and Safety Act rather than the Fair Work Act, and means under the Work Health and Safety Act, an individual who performs work in any capacity, including as an employee, a contractor, a subcontractor, an outworker, an apprentice, trainee, student on work experience, or a volunteer. So it does have a very broad definition. The Act provides that a worker can make an application for an order to stop bullying where they reasonably believe that they have been bullied at work. There is no time limit to make that application, but there is a fee that needs to be paid when making the application. And the Act specifically contemplates having parallel applications, so it specifically contemplates that workers could have applications in, for example, the work health and safety jurisdictions. It does have a broad coverage of behaviour in workplaces. So workplaces is a broad term, and it means a constitutionally covered business, which is something that draws in both the definition from the Work Health and Safety Act of a person conducting a business or undertaking, and is also a constitutional corporation, so that's a trading or financial corporation, the Commonwealth or a Commonwealth authority, so federal government employees and federal government authorities, a body corporate in a territory, so in the Northern Territory or the ACT, and that the business is conducted principally in a territory or a Commonwealth place. There are some specific exclusions in relation to the Australian Defence Force and the Australian Federal Police. So if those are people that you might be advising, they certainly need to check those specific exclusions. Bullying has a specific meaning under the provisions of the Fair Work Act, where it is unreasonable behaviour by an individual, and it's not reasonable management action taken in a reasonable.
Seem to be having a technical issue for a moment.
Create a risk to health and safety of the worker. This is obviously expands on the current definitions that are available in relation to bullying, of which under work health and safety legislation is not currently as specific. In order for the Fair Work Commission to make an order, there must be a risk of the bullying at the time of considering any order. That means that a worker still needs to be experiencing the bullying behaviour if the Fair Work Commission were not to issue the order. And so there have been a number of decisions of the Fair Work Commission to date that have looked at what issues might arise where the employee is no longer working at the workplace, or they have resigned, and those decisions have suggested that where an employee is no longer working at the workplace, they are not at risk of bullying continuing, and so the Commission has not been able to make an order in relation to the behaviour.
So Jennifer, what you're saying that the you need to stay at work in the situation for the case to be mediated, is that?
So you still need to be, for the Fair Work Commission to be able to exercise its power to make an order to stop bullying from occurring, they need to be satisfied that there's a risk that the bullying will continue. And this is consistent with the objectives, so this is consistent with the objectives of the legislation, which is to prevent bullying from continuing. Because there's no compensatory amount that's available under the types of orders a Commission can make, it's not a punitive jurisdiction. It's really more to assist the person who's made an application to be able to continue in the workplace without bullying from continuing. Obviously, where they are no longer in the workplace or at risk of that behaviour continuing, perhaps because the person who has engaged in the behaviour themselves no longer works there, then the Commission may not be able to be satisfied that the bullying will continue.
Oh, right, I see.
And so this jurisdiction is looking at the conduct of individuals in the workplace, so it's not necessarily the employer's conduct per se. It's not as in the work health and safety jurisdictions where it is the employer's responsibility, as well as other workers, their responsibility to ensure a safe workplace. It is looking quite specifically at the conduct of the individuals at the workplace. And it's not necessarily that the individual is another worker. It is broad enough, at least at this stage, to be contemplated that it is a client or a visitor to the workplace as well. So the role of the Commission is to start dealing with the application within 14 days of the application having been made. That generally looks like, and I'll go through the case management process in more detail, but the Commission commencing to deal with the application by receiving an application and serving that on all of the parties to the matter and inviting a response to the application. Obviously, the Commission can only deal with the matter on application. So the Commission doesn't exercise the power specifically without the application having been made, and they have to be satisfied both that they have been bullied and there is a risk that it will continue. So as I said before, the order is directed to prevent them from being bullied, but cannot include a pecuniary amount. So the Commission has no jurisdiction to order compensation, but otherwise the types of orders that the Commission can make are very broad, and we'll discuss some of the orders that have been made in a moment. The Commission must consider any known outcomes of work health safety investigations, internal grievance or other procedures, and any other relevant matter. So the case management model that the Fair Work Commission has developed, which was in consultation with a number of the key stakeholders in this jurisdiction, the main issue to consider when case managing these types of matters is that the Commission has determinative powers, and therefore natural justice obligations in dealing with matters need to be satisfied. So the Commission, when looking at case managing these applications, ensure an early and prompt assessment of the applications. There is some initial engagement with all of the parties to the application. So that includes the worker who's made the application, the person who they've named in the application as having engaged in bullying behaviour, and the employer. There is some streaming and prioritisation of matters, and that's why the early and prompt assessment of the applications is critical, as we are looking for some of those instances at the outset where there are concerns around physical elements of the bullying behaviour, or any sort of indication from the applicant around their concerns for their own safety. There's certainly a case-by-case approach taken to each matter, and mediation or conciliation is only offered where it's appropriate and it is voluntary. So that's not necessarily, it differs from the unfair dismissal jurisdiction where all matters are conciliated. In the anti-bullying jurisdiction, it's only where it might be appropriate. And so there's early assignment of matters that are proceeding to members, so they are then allocated quite swiftly after the case management has occurred. And that case management and the proceedings before members take account of the nature of the parties, the relationships and the alleged behaviour. So typically what we would see is that the application is lodged. The anti-bullying team confirms information in the application and provides information on the process and confirm the desire to proceed with the applicant. And we identify any obvious jurisdictional problems, so if it doesn't appear that they've been engaged by a constitutionally covered business, for example. Then service is affected on the employers, and in most cases upon the individuals named. The anti-bullying team confirms the information on the application and provides information on the process to those parties as well. So part of the case management process has included ensuring that we are serving the correct individuals to their correct either email addresses or postal addresses to ensure that the material remains confidential to the parties who are involved in the process. They have the opportunity to then provide a response, and the panel head makes decisions about every change to the rules of service. So if parties seek further time to respond to their application, as they normally have 7 days, and the panel head considers all of those types of requests. The anti-bullying team then collate and provide all of that information to the panel head. And then the panel head, so who is a member of the Commission, decides how and when the matters will be dealt with. So they will either decide that it should be dealt with by mediation, and those mediations, it's very clear from the outset that there's monetary settlements are not, those types of discussions are not entered into by the mediators. Or the matter is then assigned to a member to deal with as they see fit. So it will be at the discretion of the tribunal member as to how the matter will be dealt with. There is obviously jurisdictional determination if there is issues of jurisdiction in the matter. And in most cases what we're seeing in practice is that members are often conducting at least a preliminary conference to assist the parties, at least with stabilising the relationship, and so that the parties can work out how they will deal with each other until the matter is substantively dealt with. So we are seeing quite a few of those preliminary conferences at an early stage, at least to assist the parties with how they might then deal with each other once the application is then in the workplace. So the members do have the orders depending on the nature of the parties and what's at play at the workplace.
Jennifer, I think sorry,
and
Jennifer,
then
we had a brief,
should the matter not have been, sorry,
you dropped out there for a minute. Would you mind actually starting again from the beginning of that slide? Okay.
Oh, okay, yeah. Yep, so there is the opportunity to determine sort of threshold jurisdiction issues at the start, and that members are often also convening preliminary conferences. So that's likely in most matters so that the relationship at the workplace can be stabilised and parties can work out how they will deal with each other until the matter is substantively dealt with. So members are convening those initial conferences to give the parties at least the opportunity to work out how they're going to deal with each other until the matter is dealt with potentially more formally. There is the opportunity to use conciliation or other ADR processes, and urgent hearings for interim or other orders can certainly occur if they are required. And certainly if matters aren't resolved through any of those other processes, then there is the opportunity for to hear the merits of the application and a remedy around whether or not an order should be issued. And that can be done either by hearing or by a determinative conference. So members may hold an open to the public hearing, or they may conduct a determinative conference, which is a conference where they might be slightly more directive with the parties around and might ask more inquisitorial, so they might ask them questions, more questions than they ordinarily would in a hearing.
Now, why would you have an open hearing? What would be the purpose behind that?
Well, I suppose it's really more that's contemplated in the Fair Work Act. The anti-bullying provisions don't of themselves have a separate means by which matters need to be disposed with. So the current provisions under Section 592 and 593 of the Fair Work Act still apply, and so a conference may be held or a hearing may be held. So it's really up to the member, to decide how the matter should be to be dealt with. So the Fair Work Commission published its first quarterly report after the end of the first quarter this year, and the number of applications lodged have remained consistent each month. I can't talk in specifics about the number of applications that have been lodged. We are looking to table our annual report, which will have all of those details in them, and then we will certainly be publishing further quarterly reports indicating the specific numbers around lodgements. But suffice to say that there hasn't been a great influx of applications. It's a lot smaller compared to some of the other jurisdictions that the Commission deals with.
Do you know why that is? I mean, I think there was speculation at the time that this might create a huge influx of anti-bullying type applications, but that hasn't seemed to be the case. Has the Commission sort of worked out why that's the case? Or?
Look, we haven't, and I suppose really from my own experience as having looked to implement the jurisdiction and then now having been managing it, there's no clear indication of why or why not people have been accessing it. So I suppose, you know, I'd in fact be interested to hear from some of those who might be listening today about what they see as, if there hasn't been that, well, since there hasn't been that influx, what might be affecting that. But there's no one clear reason for that that we've been made aware of, at least at this stage.
Yeah, so as Jennifer mentioned, if any of you have any of your own thoughts on this matter, please feel free to post them in the chat box down the lower left corner, and we can have a look at that as well. Thanks.
So, and the triage process that we have in place appears to be working effectively to confirm applications and facilitate effective responses. So we are spending a great deal of time with the parties to the application to ensure that they're aware of what the process is and the importance of having responses from those who are involved in order for the Commission to be able to then deal with the application effectively. So we have commenced 100% of the matters within that 14-day period required, and a proportion of applications are withdrawn when the nature of the remedy or the jurisdictional requirements are confirmed. So some of those applications don't get served on the employers. And that can often be where the applicant is seeking something, for example, some sort of compensation as a result of making that application. We make that very clear to them from the outset that that's not the objective of the jurisdiction, and that's not something that the Commission can order. And quite a number of applications are dismissed due to being incomplete or non-payment of the fees. And you may have, if you have been following the Commission's decisions in relation to the anti-bullying jurisdiction, you will have seen a number of decisions dismissing applications due to being incomplete or non-payment of the fees. So they haven't been substantive assessment of the merits of whether or not bullying has occurred. It's really more an administrative dismissal of those applications.
Right. Can you remind us what the fee is?
Yes. Just one moment. I believe it is $67.20. That information is available on our website when making the application as well.
Okay, thank you.
Yeah. I will confirm, yes, it's $67.20. It was recently, it's indexed annually, so it was recently increased. Yep. So of the applications we've received, most have involved alleged bullying by fellow employees or managers or supervisors, and the issue of reasonable management action is regularly raised by employers as well. So we've not seen a great number of applications that do involve external parties to the matter. And there is strong representation of clerical, education, health and welfare and retail industry. Many, if not most, of the parties are self-represented, including the applicants. So a lot of the applicants make their application without being represented and often continue to remain that way throughout the progress of their matter through the Commission. Whilst the matters, 95% of matters have been assigned to members to deal with. 55% of matters have been resolved by agreement. So that's where parties have come together in a conference context and they have agreed to either training, mediation, clarification of their roles, revised reporting arrangements, undertakings on behaviours and policies have been updated. So those have been resolved by agreement without requiring the Commission to issue an order. 30% of applications have withdrawn, and that often occurs up until and after the applicant has actually received a copy of the response from their employer. So we are seeing a number of applications then withdrawing once they've sort of gone through the case management process and they're about to be assigned to a member. When applicants have then received a copy of the response, they have often then withdrawn their application as well. So it might be that they're then satisfied with the response that they've received or decided not to pursue their application any further. And 16% have been dismissed, mainly through, as I said before, incomplete applications or on the basis of jurisdiction, and there have been 1 or 2 on the basis of merit. So there have been 3 orders made so far in relation to stopping bullying behaviour, and those orders have been made by consent of the parties. So those orders indicate that the parties have, and it's usually through a conference process, that the parties have agreed to the outcome of the order that's eventually issued. Other applications that are currently on foot are being considered by the Commission, so most of them in that preliminary conference, as I said before, and there are some decisions obviously pending. So that is where the sort of the numbers are up to. So some of the decisions that the Commission has made, or some of the issues that the Commission has ordered, we've got the full bench decision on whether or not conduct prior to the 1st of January 2014 could be considered in determining whether or not bullying had occurred. And the full bench decided that it's basing it on future action on past events and hence is not properly characterised as retrospective. So the legislation the full bench considered was not looking at retrospectivity. It was really looking at future actions, and the past events itself were determining whether or not the jurisdiction was enlivened. So the commencement provisions were looking at applications after the 1st of January, and so they decided that applicants were able to rely upon the 1st of January conduct. But obviously there is still that necessity on the applicant's part to demonstrate that there was future risk of bullying occurring. So there have been other decisions and orders by a single member, so that's the only full bench decision we've had thus far. Some of those other decisions have looked at whether or not they've worked in a constitutionally covered workplace. The Balthazar against the Department of Human Services matter looked at whether or not someone who was receiving carers benefits could be classed as a worker, and the behaviour that he experienced when attending at Centrelink offices. The application by SB is a decision on whether bullying occurred in that regard, and Shaw also looked at whether or not there was risk of bullying continuing. What you'll find is that some of the decision titles that have been or some of the decisions that are published have the applicant's name either just indicated application by applicant or application and then their initials, and that's where a member has decided to suppress the names of the parties. So it does happen in some but not all matters. And looked at whether or not they were a corporation, and it was found, at least in SW, that they weren't. And so some of those other cases have looked at, for example, Caulfield looked at the application for de-identification of parties, as I was just talking about before. That matter was looking at whether or not the names of the respondent employer should be published. And at that time, it was decided not to issue a suppression order in relation to those details. And Hill against the Southern Highlands taxis looked at whether or not there are any reasonable prospects of success where the applicant had in fact resigned his employment prior to making his application. It was found that that's one of those matters where it was found that there was no risk of bullying continuing as he was no longer at the workplace. So the Commission in implementing this jurisdiction has put together a number of different resources, which includes a bench book, and the bench book looks at some of the decisions that have been made thus far, and also looks at more broadly some of the other jurisdictions that may have comparable precedents that may be applied to the anti-bullying jurisdiction. Also published our case management model, and we have a detailed guide on our website about the jurisdiction and how matters are dealt with. We've also got the Fair Work Commission rules, which set out the rules for service of applications, and the forms themselves are also quite detailed, both for the applicant and for the employer. So we have published our first quarterly report, and then the annual report will be published in the near future. So that's where I might leave it, Ray, unless you had any sort of questions before you wanted to go.
No. Thank you very much for that, Jennifer. That's certainly an area of great interest with our listeners, and I'm sure people will be really interested to see what comes out in the first annual report, gathering all that information. When do you think that annual report would be coming out?
Look, I think that it will be tabled later next month, but we don't have a firm date yet at this stage.
We'll keep an eye out on that, and no doubt we'll be reporting on that in Workplace Info and providing you with a link to go and download that information. So thanks very much for that, Jennifer. Now, Paul Monroe, you've got an eye on a whole range of activities that are going on in the workplace. What other things are happening at the moment?
Hi everyone. Hi Ray. Yeah, just a few things I'd like to cover that have happened recently. Some things that I think will happen in the next few months, and just keeping an eye on some things that are ongoing. There was a recent High Court decision handed down a couple of weeks ago. And this has been running around for a while. It's gone through the Federal Court, full court of the Federal Court, and finally determined by the High Court. It involved a fairly complex argument about legal principles involved in contracts of employment. It's very much the area of the lawyer. But what it involved was the principle of mutual trust and confidence. Federal Court adopted UK law in applying an interpretation in this particular case. But this particular issue or concept was overturned by the High Court. I guess some of the details of it, what the High Court determined was that a term of mutual trust and confidence should not be implied by law in employment contracts. The decision was handed down in a matter of, it was the Commonwealth Bank versus Barker. What the case involved was that the applicant alleged his former employer had failed to follow its redeployment policy following his role becoming redundant, which he contended amounted to a breach of an implied term of mutual trust and confidence, resulting in him being denied a redeployment opportunity. In arriving at its decision, the Court distinguished an employee's implied duty of fidelity to their employer from a term of mutual trust and confidence of the nature in question. The High Court considered whether the latter term was necessary to give efficacy of the contract, and in the specific circumstances of the case, the Court found that a contract of employment would not be rendered futile in the absence of an obligation to attempt to redeploy an employee. However, beyond the specifics of the case, what it really means is that nothing has changed. If the full court of the Federal Court decision had remained, then there would have been a number of consequences that were involved in that, particularly with the way that contracts of employment are drafted. So what they found was that contracts of employment generally do not require an implication of the term for their effective operation. The High Court's clarification that mutual trust and confidence should not be implied in employment contracts is an important one for employers confronting employees' claims. Suggestions of an implied term of mutual trust and confidence by disgruntled employees had become commonplace and applied liberally in cocktail claims with the potential to impact settlement outcomes and litigation costs. The consequences were that if the appeal had been unsuccessful, there was the potential problem that employment contracts would have required redrafting at considerable expense to employers. So what that means is that the status quo is maintained. So what's this mean for your business? Well, fortunately, this decision provides some comfort that where an employer fails to comply with a policy or procedure, or otherwise fails to consult generally with an employee outside any specific obligation to consult, the employer will not be liable for some obscure claim based on an implied term of mutual trust and confidence. The decision reinforces that employers should ensure their contractual arrangements with their employees adequately address only those matters that are appropriately dealt with in an employment contract, keeping policies and procedures separate. And this has certainly been the advice from legal advisors previously. The decision also cautions that employers still need to be mindful of the obligations to act in good faith in the performance of an employment contract and obligations not to exercise powers or discretions granted by a contract in an unreasonable manner. Accordingly, employers ultimately still need to ensure that when they exercise contractual powers or discretions, they don't act in an arbitrary way. So, for all the people there who aren't lawyers, and that, I must admit, includes myself, what is mutual trust and confidence? Long been a contentious issue in employment contract law, and I guess the High Court decision has finally determined that in the Australian context. I guess, nevertheless, it can be categorised as another individual employment right that has been gaining importance in recent years as collective rights are tending to decline. There are legal obligations on both the employer and employee to comply with the terms of the employment contract. These include the duty of both parties to give reasonable notice of termination of the employment contract unless a breach of it is involved, duty to cooperate with the other party. Parties cannot, without reasonable and proper cause, conduct themselves in a manner likely to destroy or seriously damage the relationship of mutual trust and confidence. Australian cases have added that a breach of the employment contract can amount to repudiation of it, employers' duty to apply beneficial but non-binding employment policies, and a duty not to suspend an employee from his or her duties capriciously, or a duty to refrain from publishing false or injurious statements. So it's a fairly detailed, complex area of law that usually would involve senior members of management. It would be unusual for it to involve a question with respect to blue-collar, white-collar type employees or award-covered employees. The term is used occasionally, not in this context, but in the context of unfair dismissals with respect to reinstatement, where the employer might argue that rather than having the employee reinstated where the person has been deemed to have been unfairly dismissed, that there's been a breach of trust and confidence. That's an argument that's, that may be successful with respect to rebutting a reinstatement order in an unfair dismissal matter. So the good thing from the decision, as much as it's a High Court decision, that in fact the High Court has maintained the status quo. So provided your contracts of employment have been adequate before this decision was handed down, then this decision won't impact on any changes, and you won't need to make any changes as a consequence of this High Court decision. So that's some good news in that respect. Just on another issue that we've been receiving some inquiries from subscribers to Workplace Info on the issue of the ability of the employer to close down at Christmas. This made the press last year, actually. A couple of high-profile companies were mentioned in the paper after introducing a policy of deciding to send their employees on annual leave over the Christmas New Year break, primarily because the employees had accrued significant amounts of annual leave. In larger companies in particular, the irony is that the worst offenders with respect to accrued annual leave balances, or high accrued balances, usually is middle and upper management. However, in the few cases that were reported, they were professional organisations and involved people who were professionally qualified people. These people didn't seem to like the idea of this being introduced. However, a lot of the subscribers to Workplace Info hadn't even considered this as a possibility as a means of being able to lower their liability for or exposure to large amounts of accrued long service leave. Usually companies look at it in terms of maybe cashing out as a potential possibility. The provisions of the Act under the NES with annual leave generally require there to be agreement between the employer and the employee when taking annual leave. So therefore, sending somebody on annual leave is not necessarily something contemplated by the Act unless in certain circumstances. Now, Christmas and New Year period is something that's mentioned in the legislative note with respect to non-award type employees. So the employer would be able to close down their business with respect to award agreement-free matters, as this is noted by the Fair Work Act. The problem has really been with modern awards. The ability to be able to close down at Christmas as an annual shutdown is not something that was originally a standard clause in modern awards. However, most modern awards now do contain a provision which is similar to that's prescribed by the Fair Work Act, and that is that subject to notice requirements, that the employer is able to send people on annual leave over the Christmas, particularly over the Christmas New Year period. It may be difficult if the company contemplates using this mechanism if there is a downturn in trade. The Federal Court has made some comments about that, stating that for the purposes of an annual shutdown for annual leave purposes, it's more to do within the context of breaks in business with respect to Christmas and New Year breaks. Could possibly also apply to Easter, depending on the circumstances of the business and the industry in which the business or the employer operates. So I guess the bottom line is that in directing employees to take annual leave, you should consult the award if these people are covered by an award. The award these days should generally give you some relief in being able to do that. And it is something that more and more employers, judging by the number of inquiries we've been getting from Workplace Info, from our subscribers, is something that is being seriously contemplated by more and more companies as a means of lowering their liability for annual leave. So it's not something that is not permissible at all. The other thing that we've been getting some questions on is Anzac Day next year. Whenever a public holiday falls on a Saturday or a Sunday, it's amazing the number of inquiries we get about additional holidays being gazetted or declared by the relative state or the relevant state or territory government. Anzac Day in 2015 falls on a Saturday. According to press reports, some governments have already announced that they will not be considering declaring an additional day for Monday the 27th of April, they being New South Wales, Victoria and the ACT. But a perusal of the state public holiday legislation in the other states such as Queensland, South Australia and Tasmania, and also the Northern Territory, doesn't have any automatic declaration of a holiday on the Monday, so therefore unless there is some administrative action by the respective state or territory government, Saturday the 25th of April will remain the day observed as Anzac Day for 2015, and no public holiday or no additional day would be gazetted for the Monday. The exception to this is Western Australia. Their legislation actually specifically states that when a public holiday, when Anzac Day falls on a Saturday, the following Monday is declared as a public holiday as well as the Saturday. So with the exception of Western Australia, at this stage, no other day is going to be gazetted in addition to the Anzac Day holiday next year. So if people are planning their rosters, planning their holidays, etc., that may give some help as to what may be happening in that particular space.
Paul, is that a bit harsh with the 100th anniversary coming up and that sort of thing? Like what happened last time this happened, which would have been, I presume, 5 years ago or something like that?
Anzac Day for some reason seems to be a special holiday in the sense that for example, next year Boxing Day will fall on a Saturday. Now, I'm sure that Boxing Day, the following Monday or Tuesday, depending on the state or territory, will be an additional holiday for Boxing Day. So in terms of other holidays, moving holidays like Christmas and New Year and New Year's Day, Christmas, New Year and Boxing Day, governments tend to, and state and territory governments tend to gazette additional days in response to that. Anzac Day, as I say, seems to be a special day, except when it falls on a Sunday. So in 2016, without knowing what the calendar is in 2016 as to whether it skips the Sunday or not, if Anzac Day falls on a Sunday, you may very well find that the following Monday will be gazetted a holiday for reasons that in a lot of states and territories, observance of public holidays on Sundays doesn't seem to occur, although New South Wales seems to be an exception, having gazetted Easter Sunday as a public holiday in its legislation. So yes, Anzac Day seems to have that special meaning, and with state and territory governments. And as I say, their legislation doesn't automatically provide for this either, so it'll require some administration or administrative. I'd also think that it'd be a COAG thing, as much as Western Australia has legislation which means that they will have an additional day. It would require, I would think, the other states and territories to come to some consensus that would apply across the board, rather than it just being something that's decided by each individual state and territory on its merits. I guess just a reminder is that there are some terms in modern awards that will expire at the end of this year. When modern awards were introduced back in January 2010, there were some transitional provisions placed in modern awards that recognised conditions that existed under pre-existing federal and state awards. These are in the area of redundancy pay, accident pay, and in some awards that prescribe district or location allowances. It was mainly an issue in certain states. For example, with redundancy pay, New South Wales had always enjoyed a more beneficial scale of redundancy pay than in the federal jurisdiction. The National Employment Standard, when it was introduced redundancy pay across the board to all employees, and adopted the federal scale that applied under federal awards at the time. So the more beneficial provisions of redundancy pay under New South Wales or previous New South Wales state awards would no longer have applied. However, there was a phasing in, or not a phasing in, but a transitional period put into 5 years where the employer would still have to observe the more beneficial provisions of the previous state award, or NAPSA as it was called under work choices, until the 31st of December 2014. So from 1st of January 2015, redundancy pay, unless there's something else prescribed in an individual enterprise agreement or under the individual's contract of employment, all employees' entitlements with respect to the scale of redundancy payment will revert to the scale under the National Employment Standard under the Fair Work Act. The other condition that was a transitional provision was accident pay. This didn't exist in a lot of awards, although it was common in federal awards. And this was where there's a make-up pay between someone who's on workers' compensation and their actual rate of pay or the award rate of pay, where the level of workers' compensation was less than their ordinary rate of pay. That was actually a condition that applied whilst the person was on workers' compensation, so it wasn't necessarily related to the person's continued employment with the employer. That will also go on the 31st of December, so any of those provisions that currently, accident pay provisions that are prescribed by a modern award, will no longer apply. District and location allowance is something that usually more in the remote areas of Western Australia and the Northern Territory. These two will be phased out as well, so that there will be no longer additional allowances for working in specified remote areas within Western Australia and the Northern Territory.
Right. Okay. Now, Paul, we had a question that's come in from one of our participants, which I might ask you now about a Christmas shutdown issue, and I think this is one of these questions that a lot of people have. They're saying if a company decides to institute a shutdown and there's a worker that doesn't have sufficient leave saved up to cover that period, do they have to take some of that time off on leave without pay?
Well, my reading of that is that annual leave has to be paid. So this is one of the things that differs from the provisions that applied prior to Fair Work. It was very common for awards and also legislation, annual leave legislation, to allow for the standing down without pay of a person who had insufficient accrued annual leave during a close down. Unless the award says otherwise, then I think that it's got to be paid. Off the top of my head, I can't recollect an award that actually specifies it.
But does that mean that they go into the red with their annual leave, or does the company just have to cover that period even if they don't, almost like an extra annual leave payment?
Because the purpose of it is annual leave, on my reading of it, it would be considered annual leave in advance. So, and that's allowed. That's allowed by agreement between the two parties. So, I guess the difficulty from the employer's perspective, and this is something that's probably unavoidable, is that if the employee then goes on leave and doesn't come back, the Act doesn't allow deductions from their accrued annual leave. So there's some difficulties with that. I'm not sure that was something that was discussed in the review of the Act. There was a number of issues with relation to annual leave that were the subject of the review in the federal Fair Work Act. I'm not sure that was one that was actually covered in there. Now, whether even an award, if it did say it, allowed it, and whether or not that was something that was less beneficial than the standard, that would be an arguable point in any case. So it may very well be that it would have to be considered annual leave in advance under the NES. But it's another one of those issues that like with annual leave loading, payable on termination and the like, that
and does the worker have a choice in
raise
that?
their head. Not with a close down, no. The close down is to meet the needs of the employer's business, and the purposes for that generally revolve around, there's a presumption in the Act that it talks about Christmas and New Year. There's a presumption in the Act that that's a quiet time of year. Certainly know from the Chamber's perspective, where it's the same sort of thing applies with employees where I work, that basically closes down, mainly because the courts are closed, the industrial tribunals are closed or on skeleton staff, so our business varies around that period of time, as it would, I'm sure, with a lot of other businesses as well. The other thing to bear in mind too is that the close down doesn't have to apply necessarily across the board to everybody in the organisation. An example I could think of is that the company may close down its production area, its factory area, but its maintenance fitters may be required to work during that period because it's a great time to be doing routine maintenance on machines when they're down, so there's no loss of production in that sense. So it can also apply, the close down, or the close down can also apply to a section or sections of people within an organisation as well.
Mm.
I guess lastly, people are sometimes asking what's happened to the paid parental leave bill. Well, at this stage, nothing has progressed. I guess that originally the thing that concerned employers when there were discussions being held earlier in the year was that the provisions of the Act, or the proposed Act, would override existing company paid parental leave entitlements. Now, after some lobbying, that was removed from the bill, or the bill as presented to Parliament preserved existing parental leave, paid parental leave provisions in enterprise agreements or company policies, which was important to a lot of the particularly large companies generally seem to be the ones that have paid parental leave conditions. They see it as a means of being an employer of choice. It's one of the conditions. It's not the only one, obviously, but they see these provisions as something that means that they are a more attractive employer to certain categories of employees. It also helps to retain people as well as attract people. So it's something that those companies actually lobbied for it to be removed from the bill. So at this stage, there's been no movement there at all. So thanks everyone for listening to me, and I'll hand you back to Ray.
All right. Well, thanks very much for that, Paul. We were going to try to fit in a discussion about privacy as well, but looking at the clock, I can see that we've had so much discussion around these current points that I'm afraid we've run out of time, but we have covered that a little bit in past webinars, and we will definitely be discussing that in upcoming webinars as well. So if you want to keep your eyes out on Workplace Info for future discussions regarding what you need to do about the new privacy legislation. So we do hope you found today's session useful. Please feel free to drop us a line at editor@workplaceinfo.com.au if you have any follow-up questions, and make sure you log on to Workplace Info and Workplace OHS for the latest info on compliance and best practices for HR, IR, and work safety professionals. And as Jennifer mentioned, if you have a look at fwc.gov.au, you'll be able to find out more information about the activities of the Fair Work Commission. If you want to revisit some of today's presentation, excuse me, an archive will be published on our YouTube channel, which you can watch and listen to at your leisure. The URL will be included in our follow-up correspondence. I will also be sending you up some follow-up information on the topics we've talked about today, which we hope you'll find useful. Tune in for our next webinar, which will be on the 23rd of October. We'll be dealing with leave issues. So we thank you for your time and wish you the best of luck with your work.